Robin, if you're ready, we're going to go. All right, you're muted, but I think that there's a positive. Okay, very good. Good morning, all. I'm Dwight Keene. I'm the chairman of the Kansas Corporation Commission. I'm joined this morning by my fellow commissioners, Susan Duffy and Commissioner Andrew French. At this time, I'm convening the hearing on the unanimous settlement agreement on a waiver of the penalties under KGS tariff in the matter of the investigation into Kansas Gas Service Company, a division of One Gas Inc., regarding the February 2021 winter weather events, as contemplated by docket number 21 GIMX-303-MIS and docket number 21-KGSG-332-GIG. Due to the pandemic, we are conducting this hearing by Zoom and broadcasting to the public on YouTube. Please bear with us if you experience any technical glitches. Let's begin this morning with the entries of appearance, and we'll start with KGS.
Good morning. My name is Kelly Daly. I'm with the law firm of Snell and Wilmer. I would also like to enter the appearance of James Flaherty of Anderson and Bird and Charlene Wright of Wright and Associates.
Thank you, Kelly. Next, Symmetry.
Good morning, and may it please the commission, Frank Caro with the Polsinelli Law Firm, along with Sean Pluta on here, and also Catherine Sawyer, I believe, Molly Weiler, and Margaret Tuff with the Latham and Watkins Law Firm, all of us representing Symmetry Energy.
Thank you. Atmos.
Yes, Ed Peterson, appearing on behalf of Atmos Energy.
Thank you. Freedom Pipeline. Either Glenda or Kyler, are you on yet? All right, let's move on to Blue Mark and Wood River.
Good morning. Entering an appearance for Blue Mark and Wood River, Alex Goldberg with the firm of Evershed Sutherland.
Thank you. The Wichita Diocese, Foley, and Central Christian Church.
Good morning. My name is Ed Watson of the law firm of Folston Seaskin.
Thank you. NGTCC.
Good morning, Commissioners. Jim Zakora and Connor Thompson on behalf of the coalition.
Thank you. Constellation.
Good morning, Joshua Harden with the law firm of Collins and Jones on behalf of Constellation New Energy Gas Division, as well as Amy Baird with the law firm of Jackson Walker, also with Constellation, or on behalf of Constellation.
All right, thank you. The Kansas Attorney General's Office.
That's not a good sign.
Melanie, are you on? We'll move on. Citizens Utility Ratepayer Board.
Good morning, Commission. This is David Nickel on behalf of CURB.
Thank you. The KCC staff.
Good morning, Chair Keene. Terry Pemberton appearing on behalf of Commission staff and the public generally.
Thank you as well. Let me double back just for a moment here. Freedom Pipeline. Glenda or Kyle, are you on? Okay. And doubling back once again to the Kansas Attorney General's Office. Melanie Jack, are you there? Okay, very well. Does the staff have a recommendation regarding notice?
Yes, we do. The Commission issued its order amending the procedural schedule concerning waiver of penalties in KGS's tariff on January 25th of this year, the subject of today's hearing. The order set the hearing for today's date, Friday, February 4th, beginning at 9 a.m. to be conducted via Zoom. Subsequent to the order, or the order was issued and served on all parties to this proceeding, and subsequent to that, the parties convened to discuss preliminary matters and matters concerning this hearing. So with that, staff recommends finding by the commission that notice was proper and the commission has the jurisdiction to hear this matter at this time and place.
Thank you, Terry. Are there any objections to notice? Hearing none, I find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let me handle a few preliminary matters next. Just a few notes on the conduct of a hearing, this hearing via Zoom. First, if any party encounters any technical issue today, I encourage you to ask to go off the record so that we can resolve the technical issue off the record. Second, if the commission needs to deliberate, we will be going off the record, entering into a Zoom break room where you can't see us or hear us, and then subsequently returning. Third, since we are participating at a distance, please be especially careful to identify exactly what you are referring to when discussing pre-filed testimony and exhibits. We have copies of all of that on hand, so we should be able to follow along if you identify it. Fourth, since we have both confidential and highly confidential designations under our protective order, the commission would appreciate the party's assistance in being extra vigilant about identifying when they are introducing confidential or highly confidential information so that we may ensure that only people who have executed the proper NDAs are able to hear the testimony. I understand that the parties may wish to admit pre-filed testimony into the record. In fact, I understand that KGS intends to do so. Is that correct?
Yes, it is. If this is the appropriate time, I would like to introduce the rebuttal testimony of Bernadette M. Johnson on behalf of KGS that was filed on January 7th, 2022. And also the testimony of Matt L. Robbins in support of the settlement agreement on behalf of KGS, filed on December 1st, 2021. At some point, if this is appropriate, I would also introduce the testimony of Janet Buchanan in support of the unanimous settlement, but because she is appearing today, I was going to introduce that evidence when she is proffered.
This is fine. You've done it now. That should be adequate. Thank you, Kelly. Are there any objections? Without objection, all of the foregoing are admitted. Any other parties wish to admit or move to admit pre-filed testimony into the record at this time?
Mr. Chair, this is Frank Carroll on behalf of Symmetry. It was my understanding that all pre-filed testimony would be admitted into the record. Is that not the case?
Brian?
Sure. It is the case, but a lot of times for housekeeping, we'll have somebody move all of it into the hearing. But I mean, to me, once it's been filed, it's part of the record. But okay. So.
Thank you, Brian. That's exactly how we're going to treat it, Frank.
Right.
They're all pre-filed. I guess in the case of KGS, we have double duty.
Okay. Thank you, Mr. Chair. That's what my understanding was too.
All right, thank you. I appreciate the question. It clarifies it for all parties in attendance for certain. Okay, very well. Are there any other preliminary matters that we wish that any parties wish to address?
Chair Keen, just I wanted to note that it appears that the AG's office, Ms. Jack has joined.
Oh, very well. Thank you. We have gone through an entry of appearance. Ms. Jack, it's nice to have you joining us. Would you care to enter your appearance on behalf of the Kansas Attorney General?
Thank you. On behalf of the Attorney General, Derek Schmidt, Melanie Jack, Assistant Attorney General, appears.
Very good. Thank you. Glad to have you with us. Thank you for that, Brian. Let's briefly consider the procedures for this hearing. I understand that the parties wish to make opening statements. KGS will go first, followed in order by NTGCC, Atmos, Symmetry, Curb, and finally the KCC staff. After opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. I understand that at the pre-hearing conference, the parties had indicated that that they do not intend to make closing statements, and that we also have a procedural schedule that allows for post-hearing briefs. I think that dispenses with most of the procedural and preliminary matters. At this time, we will move to opening statements. First up is KGS, Kelly Daly.
Thank you, Chairman and Commissioners. To begin with, KGS would like to express its thanks to the Commission staff for their hard work in this matter, and to all the other parties for their good faith participation in the process that culminated in the unanimous settlement being presented to the Commission today. As we all know, last February, Winter Storm Uri imposed a tremendous burden on the gas and the electric infrastructure throughout the state of Kansas. As the data in this case showed, KGS's gas supply and operations departments worked around the clock to forecast, analyze, and respond to the consequence of the storm and the needs of our customers. Despite numerous unforeseen obstacles, the incredibly hard work of KGS paid off, and the gas supply and operations departments were successful in maintaining the integrity of the system and satisfying the gas needs of its customers during the extreme weather event. At all times during the storm, KGS actions were in line with its tariff and with its KCC staff-approved gas supply plan. KGS can be very proud of the fact that during this critical operating condition, it served the natural gas needs of all of its customers, despite the fact that 93% of the marketers and individually balanced transportation customers violated both their contract and the KGS commission-approved tariff by failing to deliver sufficient gas into the KGS system to cover their gas supply obligations. The KGS tariff provides that during critical periods involving the issuance of operational flow orders, also called OFOs, or periods of curtailment, also called POC declarations, marketers and individually balanced transportation customers are required to deliver specified volumes of gas into the KGS system. To the extent that a marketer or individually balanced transportation customer delivers insufficient gas into the system during one of these critical periods, the KGS tariff imposes penalties for their unauthorized use of gas, which are 2.5 times or 10 times the index price of gas. Now, KGS does not keep these penalty dollars. Rather, they are redistributed to our gas sales customers through our cost of gas rider. KGS continues to believe that the penalty provisions of the tariff are an essential tool to enforce discipline and compliance with the tariff, especially during critical periods. And in this case, they are appropriate because the actions of marketers and individually balanced transportation customers during Winter Storm Uri threatened the integrity of the KGS system and jeopardized KGS's ability to serve the needs of its gas sales customers. However, back on May 28th, 2021, in an effort to expeditiously reduce the financial impact of the winter storm on the communities and customers that KGS serves, KGS filed a motion for a one-time limited waiver in this docket, seeking the Commission authorization to deviate from the penalty calculation under its tariff to allow KGS to remove the multipliers from the calculation of penalties incurred by marketers and individually balanced transportation customers for their violations during the winter storm. If granted, this waiver would have resulted in marketers and individually balanced transportation customers only being responsible for their volume of unauthorized gas usage multiplied by the index price of gas. KGS made this waiver request because although the tariff penalty provisions operated as they were supposed to, due to the confluence of events, including the nature and the extent of the storm and the high demands for gas, which were exacerbated by certain marketers' failure to have firm supplies dedicated exclusively to their customers on the KGS system, the market-driven index price for gas, combined with the multipliers, produced a total amount of penalties for all marketers and individually balanced transportation customers of $888,210,367. Removing the multiplier, as requested by KGS in the motion for waiver, would have reduced the aggregate amount of penalties to $117,224,479. The unanimous settlement being presented to you today, which is the product of several months of negotiations, further reduces the total amount of penalties to be paid by marketers and individually balanced transportation customers to $65,444,505. With one exception, the aggregate amount of penalties represents the total amount of unauthorized gas usage multiplied by a negotiated gas price. This negotiated gas price is equal to the weighted average cost of both the spot gas and the gas daily callable purchases made by KGS. In consideration of factors, including the implications of prolonged litigation and the representations relating to the significant adverse financial impact imposed by the winter storm, one marketer, Symmetry's obligations under the settlement was modified to represent a negotiated penalty amount that will consist of a lump sum payment due within 45 days of the commission order approving the unanimous settlement, followed by monthly payments concluding no later than the 4th anniversary of such commission order. Of importance is the fact that this marketer shall also be providing a corporate guarantee to ensure the timely and full payment of its obligations, including the carrying cost. With respect to the carrying cost included in the settlement, instead of using KGS's weighted average cost of capital of 8.6% as authorized in the commission's emergency order, KGS has agreed that all carrying charges will be calculated at 2%. Another important element of the settlement provides that any penalty amounts that KGS receives up to $52,446,581 will be credited to KGS gas sales customers. Any dollars collected in excess of this amount will be credited on a pro rata basis to all marketers and individually balanced transportation customers, with the exception of Symmetry, that delivered natural gas during the OFO and POC in excess of their tariff obligations. The total amount that could be provided as a credit is $12,997,924. Finally, within 30 days of the commission order approving this agreement, KGS will schedule a workshop for the purpose of exploring tariff revisions consistent with the lessons learned during Winter Storm Uri. All parties believe these terms are a reasonable way to ensure KGS sales customers do not bear the burden of the gas costs that were incurred by marketers and individually balanced transportation customers during the winter event. Because no party opposes this agreement, the commission evaluates unanimous settlements using a 3-factor test. 1, was the agreement supported by substantial and competent evidence as a whole? 2, will the agreement establish just and reasonable rates? And 3, is the agreement in the public interest? The testimony of KGS witness Janet Buchanan and KCC staff witness Justin Grady confirm that all of these factors have been met and that KGS gas sales customers will benefit from the receipt of the penalty amounts that KGS will collect. Thus, KGS believes the settlement is in the public interest and therefore respectfully request that the commission approve the settlement as expeditiously as possible. Thank you.
Thank you very much, Ms. Danner. Next opening statement, NGTCC, Jim Zakura.
Good morning, commissioners. I'm counsel for the Natural Gas Transportation Customer Coalition, which in this presentation will be called NGTCC or the Coalition. The Coalition currently has about 550 members located in almost every county in the state of Kansas and in eastern Missouri. The Coalition includes public and private schools, churches and synagogues, medical facilities and nursing homes, and businesses of many types. Many Coalition members are small businesses and not-for-profits and often have from 1 to 10 employees. There are 6,200 transportation customers on the system of Kansas Gas Service that account for 54% of all deliveries on the KGS system. Transportation customers are not outliers, but are instead the majority volume use segment on the KGS system. At the outset, the Coalition would offer our thanks to the commissioners and the KCC for its management of the winter weather disaster and for its equitable treatment of Coalition members in this docket. First, the emergency order dated February 15, 2021 was critical in keeping natural gas flowing to Coalition members. Without the KCC emergency order, there was a strong possibility that natural gas supply would have been reduced or curtailed to Coalition members on the KGS system and our marketers suppliers struggled to keep our supply ongoing. The unscheduled interruption of gas supplies to our members would have led to tens of millions of dollars of property damage from freezing of pipes and equipment, and a distinct possibility of serious illness and loss of life to Coalition members that serve human needs, such as nursing homes and assisted living facilities. The fact that natural gas service continued to flow to Coalition members and there was no collateral property damage from freezing of pipes and equipment permitted a framework for subsequent good faith negotiations between Coalition members and their marketer suppliers that was ultimately very successful. Second, the emergency order also made clear that the commission would require that disaster costs be kept at a minimum. The policy of the commission permitted NGTCC and CURB to strongly advocate in this docket for a 2% carrying cost interest rate on additional gas costs. The Coalition and CURB both present expert testimony in this docket in support of the 2% carrying cost component of the settlement, reducing the carrying costs from the requested 8.6012% to a level of 2%, reduced the total cost recovery by about $55 million. Third, the commission was at the forefront of natural gas and electric conservation in the February 2021 crisis. The conservation efforts made an immediate impact by materially reducing usage and greatly moderating the ultimate costs of the crisis. The commission has previously stated that in this docket, that while the commission cannot treat everyone the same, recognizing that Coalition members source natural gas in an open market setting, but the commission would strive to treat Coalition members equitably. The settlement before the commission for decision does this. It treats Coalition members and their marketers in an equitable manner. The Natural Gas Customer Coalition is a joint movement of the settlement and supports the terms and conditions of the settlement. We specifically support, number one, the 2% carrying cost component of the settlement. Number two, the manner in which the cost of natural gas is calculated for the payment of the contended natural gas supply shortfall. Three, the amount and manner of payments to be made by Symmetry Energy Solutions. And four, the clawback provisions that require credits for any future reductions in the February 2021 natural gas costs due to the ongoing federal and state investigations and private litigation. The 2% carrying cost does slightly exceed the current actual carrying costs of KGS. Michael Gorman, the consulting expert sponsored by the coalition, noted that a portion of the debt that finances the carrying costs of KGS contains a variable interest rate. His recommendation is to accommodate a likely increase in the short-term borrowing rates during 2022 while capping ratepayer exposure to possible interest rate spikes at 2%. Regarding the clawback section of the settlement and possible future credits for Kansas consumers, we continue in our resolve to obtain restitution by whatever lawful means are available to us. We continue to believe that the gas daily index prices during the period of February 12 to February 18 are incorrect. The importance of this case and other KCC natural gas cost recovery cases to everyone in the state of Kansas cannot be overstated. In our opinion, these are the most important cases to come before the commission in its history. There are 500 to 600 million of additional costs to be recovered in 3 KCC utility cases of Black Hills, Kansas Gas Service, and Atmos Energy. There are about 1 billion of additional costs throughout the state of Kansas. The KCC natural gas recovery cases are unique not only for the enormity of the amounts to be recovered, but also because more than 80% of the 500 to 600 million of additional costs will be recovered from each of the 818,948 Kansas residential customers on the KGS, Black Hills, and Atmos system. The cost for each residential customer on KGS, Black Hills, and Atmos will end up being between $600 and $688, spread out over a period of 5 to 10 years. The KCC has already approved the charge for additional residential customers on the Black Hills system. Everyone associated with this case continues to agonize over the fact that none of the individuals, churches, schools, or business customers in Kansas that will pay these additional costs did anything wrong. They're instead victims of what NGTCC believes was a dysfunctional market that increased in price from $2.54 per unit of natural gas on February 1 to $622.78 per unit on February 17. No reasonable person can view this as normal market activity. NGTC members have not been spared from the financial pain caused by the enormous increases in natural gas costs in February 2021, but we have generally resolved this issue with our suppliers and put the matter behind us. Our members have now resolved more than 95% of the February invoice disputes, about 430 cases. These cases have generally been resolved for a 20 to 55% or more discount from February 2021 invoice amounts, depending on the facts of each case. Each side compromised their contract positions for a mutually acceptable resolution. Coalition members did not have the financial cushion of an extended payment schedule provided in this settlement in this case. We were required to make immediate payment in full. NGTCC members remain absolutely committed to the market model that allows us to benefit from the free and open market for natural gas purchase and sale, and to use the regulated service for pipeline transportation and final delivery. After the February 2021 natural gas crisis, marketer suppliers and coalition members came together for a multitude of new product offerings that increased both supply security and greatly moderated or eliminated price volatility. We focused on modernizing our contractual relationships and retained our historical price advantage as compared to the cost of regulated sales service. In conclusion, the coalition thanks the Commission for its strong and effective leadership during the winter weather disaster that kept natural gas flowing to its members on an uninterrupted basis. This action, first and foremost of the Commission, saved lives, and in addition prevented extensive property damage throughout the state. We are grateful both for the equitable treatment that the Commission extended to coalition members in this and other KCC dockets, and for the Commission recognition of the vital role that coalition members play in various areas of Kansas life. Thank you very much.
Yeah. Next up is the opening statement for Atlas, Ed Peterson.
Yes, may it please the commission, just a brief statement. Atmos does support the unanimous settlement agreement that's before you today. We also supported the non-unanimous settlement and filed testimony in support of that non-unanimous settlement. We believe that our statements contained in that pre-filed testimony apply to this settlement as well. We believe that the waiver modification and negotiated gas price was a reasonable result. We also support the reduction in the carrying costs that are applicable to payments under the waiver. So again, we support this settlement and urge the commission to approve it. Thank you.
Thank you as well, Ed. Next opening statement will be for Symmetry, Frank Caro.
Thank you and good morning, and may it please the commission. On behalf of Symmetry Energy Solutions, we would first like to thank the staff, the parties to this proceeding, and the commission for their diligence and perseverance in considering and deliberating the issues before them. We thank the parties for continuing dialogue and discussion so that an understanding could be reached. Symmetry serves over 900 customers in Kansas and is the largest gas marketer in the state of Kansas. Its customers include nearly 54 hospitals or healthcare facilities, serve more than 46 separate school entities, several school districts, various government, county, and municipal customers in the state. Symmetry is not new to Kansas and has provided valuable services to Kansans for nearly 15 years. Serving these entities for many years and providing beneficial services to them and to their Kansas customers with a competitive choice for gas supply, providing value at savings of nearly 20 to 30%. Symmetry joins the other movements in supporting this unanimous settlement agreement because we feel the agreement now reflects a more reasonable and equitable allocation of costs between the stakeholders who each faced unique and exceptionally difficult circumstances in navigating the nationwide supply shocks and historic demand spikes attendant to one of the worst winter storms in recent history. Symmetry's decision to join this new settlement is influenced in large part by the parties' agreement to change the penalty calculations used in lieu of the penalties enumerated in Section 11 of KGS's tariffs. The new penalty calculations more fairly allocate the cost of gas attributable to increased system demand over the course of the storm. Because this agreement is now fairer and equitable to all parties, Symmetry respectfully requests the commission approve the unanimous settlement agreement and find that it is just, reasonable, and in the public interest. Thank you for your time and consideration and for the ability to participate in these proceedings.
Thank you, Frank. Next up for an opening statement will be Curb, David Nickel.
Thank you. May it please the commission, I am David Nickel, Consumer Counsel for Curb. At the outset, let me state the Curb does not oppose the unanimous settlement agreement dated January 20, 2022, which was filed in lieu of the non-unanimous settlement agreement, which was dated December 1, 2021. In reference to those agreements, I'll refer to the non-unanimous settlement agreement as the December 1, 2021 agreement, and the non-unanimous settlement agreement as the December 1, 2021 agreement, and the unanimous settlement agreement as the January 20, 2022 agreement. Curb appreciates this opportunity to express before the commission the reasons why we did not oppose this agreement and why we cannot support it. At the outset, let me express my appreciation for staff with regard to their hard work in this docket and other Winter Storm Uri dockets. Curb has a very healthy respect for the expertise and the dedication of staff to promote the public interest. CURB, in terms of a different methodology or different testimony with regard to how cases proceed, this never proceeds out of disrespect for the staff, but only as to a different perspective. That different perspective is important to KCC resolution of dockets. Without it, the commission wouldn't have a plethora of document or evidence and positions from which to choose how to promote the public interest. We also want to express our heartfelt appreciation for the KCC's vigilance in terms of Winter Storm Uri. As the other speakers have alluded to, it was very important that the commission confirm the regulatory compact and confirm that there was an obligation during Winter Storm Uri to keep the heat on. We also appreciate KGS's compliance with that order at great cost. Both KGS and the KCC did exactly what I think Kansas expected them to do. They followed the law. They did what was best in the public interest. However, several transporters failed to comply with the tariff 110602, and that is why we're here. Let's start with CURB's view of what the law is concerning that tariff. Transporters are charged with knowing and meeting any tariff that they operate under, including 110602. It is a filed rate in Kansas. KGS even notified transporters of their obligations under that during the storm, their obligations under that tariff, and the potential imposition of penalties as a result of noncompliance. Yet 28 out of 30 transporters violated 110602 on one or more days. 110602, that tariff is intended to keep the KGS system reliable, to keep it in balance and allow KGS to serve all of its customers. A 93% violation rate in view of the need of this tariff to keep the system in balance is a very serious violation. So in CURB's view, KGS was absolutely right in assessing that a penalty should be imposed. It is clear that the multipliers that applied during operational flow orders or periods of curtailment would result in an unjust enrichment toward sales customers. And KGS and all parties to this docket rightfully rejected that windfall. CURB was among those. We did not want that windfall for our customers. Instead, KGS sought to impose a penalty which was equal to the quantity of underdelivered volumes times the Southern Star daily midpoint price. KGS supported that as reasonable. That did not catch traction. The parties met to negotiate a different solution. The negotiations were long, and parties expressed many points of view with regard to what the right answer would be. All stakeholders, with the exception of Cemetery, agreed to a penalty which was equal to the under volumes times the average system spot price reduced by long gas supplied by marketers. We believe that settlement was reasonable. Josh France, on behalf of CURB, filed testimony supporting that non-unanimous settlement agreement. But the problem with that non-unanimous settlement agreement was that it was non-unanimous. Therefore, CURB understands and appreciates the move and the desire of all the signatories to the unanimous settlement agreement to eliminate the risk associated with it being non-unanimous. That non-unanimous settlement agreement posed a risk towards securitization of the amounts that are owed for extraordinary cost to KGS, which is a great benefit to sales customers. Therefore, for that reason, we do not oppose the settlement. However, there are certain aspects of this unanimous settlement agreement that cause us not to be in wholehearted support of it. Those are, first, that the cost of the discount granted to Cemetery is a loan borne by the sales customers. Secondly, the unanimous settlement agreement assigns gas daily quantities to transportation customers. And it's important to note that sales customers alone paid a premium for those gas daily quantities to reserve them unto themselves. And then third, we believe that the unanimous settlement agreement is parsed in such a manner as to lead to a moral hazard. Let me take those in order. As noted, the unanimous settlement agreement assigns gas daily quantities to transportation customers. That was a matter negotiated by staff and Cemetery, but even so, it was not good enough for Cemetery. Cemetery receives an additional discount beyond that methodology. It's a substantial discount, and all parties benefit from Cemetery's joinder, but the sales customers alone bear the cost of that discount. Secondly, the unanimous settlement agreement assigns gas daily quantities that sales customers paid a premium for. I can assure you that no one that paid a premium on KGS's system had the understanding that those quantities of gas reserved to be used by sales customers would be allocated to transportation customers. Low-income customers paid those premiums over time, year by year, to reserve those volumes unto themselves. I have trouble explaining to a low-income customer why those premiums didn't count. Some parties attempt to justify imposing costs on sales customers on the basis of reliability. That's true. All customers benefit from a reliable system, including transportation customers. Some urge that the sales customers are just lucky to have the transportation customers default because it resulted in less cost to the system than otherwise borne by those customers. We don't find that argument to be compelling. That argument essentially is that sales customers are lucky that the transportation customers put the system in jeopardy. Let's review the evidence on that point. In its application for the limited waiver on this, KGS indicated that the failure of marketers and some individual balanced transportation customers to secure and or deliver enough gas supply to meet their needs, there was a tangible risk that Kansas Gas Services resources would not be sufficient to maintain distribution system pressures and other operational needs, as well as to provide service to all other companies' customers during the exceptionally cold weather. Had the company not been able to acquire additional gas supplies, unplanned outages may have occurred, including possible outages to human needs customers. Widespread damage could have occurred. The truth of the matter is that we're all lucky that KGS had the foresight to be able to have the gas at hand to be able to account for these underbalances. The result simply could have been different had they not been able to secure that demand. In CURB's view, is an appropriate penalty should not be less than what the transportation customers would have paid had they acquired their own gas. The January 2022 settlement price is below that. In our view, a penalty should deter undesirable behavior, which clearly 110602 does. Do we really want to provide a precedent that may lead to transportation customers defaulting on their obligations in order to get a better price? CURB does not look at this matter as having just one answer. There are several reasonable answers. The position that KGS initially took with regard to their motion to limited waiver is supported, and CURB could support that. CURB certainly supported the January 1, 2021 non-unanimous settlement agreement, as we thought that that was a very fair solution of this matter. We also believe that there is testimony in support of this unanimous settlement agreement. We do not believe that superiority is a matter of our black and white answer. Superiority of one plan versus the other is a matter of perspective. In CURB's view, we believe that a settlement agreement that does not provide a moral hazard is superior to one that does. But the test is not whether or not one is a superior or not. We do not have to have a paradigm in each and every case. The question simply is whether it's reasonable. In sum, CURB believes that there are benefits that flow out of this unanimous settlement agreement that inure to the benefit of our sales customers. It adds certainty. It provides a clearer path to securitization. Therefore, we do not oppose the unanimous settlement agreement, and we do urge the Commission to adopt the same. Thank you.
Thank you, David. All right, last up, our final opening statement on behalf of the KCC staff, Terry Pemberton.
Good morning, Chair Keen. Good to see you, Commissioners Duffy and French. For the purposes of the record, I am Terry Pemberton on behalf of Commission staff and the public generally. And what I thought I'd do as part of my opening is to provide some background information that I haven't previously covered in one of these proceedings. And then I'll hit on the key points why staff thinks this settlement is in the public interest and should be approved. So first, I wanted to start with the distinction between this hearing and the last hearing. For those of us who have been immersed in this docket, we understand those distinctions, but maybe the general public does not. So the evidentiary hearing that we conducted back in December had to do with the amount of gas purchased by KGS during the winter storm. The questions that were presented there included, were the purchases prudently incurred? And if they were, how should they be recovered from sales customers? The settlement relating to those questions is actually currently pending before the Commission, and we anticipate the order out on that next week. What we're talking about today is a settlement that relates to certain tariff provisions of KGS, and you've heard that discussed by some of the other parties. And while KGS plans for natural gas supplies for its own sales customers, it does not plan for the purchases for the transportation customers and the marketing companies. My apologies. Under KGS's rules, as referenced by Mr. Nickel and also KGS's counsel, transportation customers and marketing companies are obligated to provide their own natural supplies for delivery to KGS. During critical periods, the failure to provide those supplies is subject to penalty that are calculated in accordance with a formula of sorts that's contained in KGS's tariff. The purpose of the penalty is to incent behavior, as indicated by Mr. Nickel. Due to the unusual circumstances surrounding Winter Storm Uri, specifically the cold weather that we experienced, the duration of that cold weather, supply deficiencies that resulted when wells were freezing off. Because of that weather and the incredible pricing volatility that occurred, it became apparent that something other than the business as usual approach to penalty imposition and calculation needed to take place. So what we're here today to discuss is a fair and equitable resolution for the failure of the transportation group as a whole to provide sufficient supplies to KGS during Winter Storm Uri. Now, before I get to the settlement terms, I thought it might be helpful for anyone watching to understand, what does it mean to be a transportation customer? People, I get that question. What is a transportation customer? I take gas service from KGS. I'm a sales customer. And the reason I want to do this is because thinking back to the calls that we received after transportation customers began receiving their bills, some of the questions were, or some of the comments were, we can't pay this bill. It's based on current market prices. It's too high. We can't pay for it. What can the Commission do to help us? Well, the unfortunate answer to that question was that we're a state agency, and as a creature of statute, we can only do what we have been delegated to do by the legislature. An added complexity to that is the fact that the federal government has primary jurisdiction over a good portion of the natural gas industry. And in part, they have deregulated the price of natural gas. That has been their choice to do that, and we have no jurisdiction to interfere with that. So in the context of this proceeding, being a transportation customer essentially basically means purchasing your gas from somebody other than your local utility. Each utility in Kansas has different views and qualifications for transportation customers, but looking at KGS's tariff, what we see is that in order to be a transportation customer under their rules, you have to be a commercial or industrial customer, and you have to use at least 800 MCF of gas in a 12-month period. While the transportation customer still utilizes KGS's system to transport the gas to its meter, the actual purchase of those supplies is made by a third-party, non-regulated entity. Now, if an eligible customer elects to be a transportation customer, it clearly moves over to a different tariff of KGS's, a different rate schedule. And under that schedule, there are certain conditions with respect to how it will provide its supply to the utility, because those supplies, again, are being transported along that system, but they're also moving along a pipeline system as well. Generally, transportation customers will contract with that third-party marketer. The company will work with the utility and the pipeline to deliver the gas to the customer. The contractual relationship between the transportation customer and the marketing company is not jurisdictional to the KCC. Those agreements are essentially for the procurement of natural gas supply, and the cost of which I've already indicated is not regulated. As I indicated also, the utility is not responsible for purchasing delivery or purchasing supplies for transportation customers, and it's also not responsible for balancing deliveries off of the pipeline system into KGS's system for those customers. Every year, we talked a little bit about this at the last hearing, but every year the utilities come in and they provide their gas plan to us. We review how much storage and transportation we think the utility is going to need for the coming year, how much supply it thinks it will need, what the projected prices may be for the coming year, things of that nature, and how the company may be planning to mitigate any pricing impacts that could occur for the coming year. And for the obvious reason that marketing companies are procuring supply for the transportation customers, KGS doesn't make those decisions for the transportation group as a whole. If we required the utility to do that, it would be uneconomical and inefficient. It would add costs to service that would be unwarranted. So when we talk about transportation in this fashion, as I mentioned, there's a pipeline system also involved. And with your indulgence, I'm going to share my screen. I have a couple of graphics. I think I'm a big visual person. So I think visual aids are very helpful. So I thought I would share a graphic that I borrowed from the AGA and walk you through what it might mean to be a transportation customer. So bear with me while I get my screen shared. All right. Are you seeing my screen? Is it blank, or do you see the transmission?
Terry, this is Dwight. We see it.
Great. Okay. So real quickly, this graphic isn't perfect for what I wanted, but it'll get the job done. There's a lot going on here. What I would like people to focus on is this large dark blue circle transmission pipeline here. And this is the pipeline system coming out here. This is a city gate of the utility. And then the utility systems on the other side of that. So where KGS has its own rules for transportation, so does each pipeline that connects to the utility. This portion of the system, of the transmission system, if it's an interstate pipeline, is governed and regulated by the Federal Energy Regulatory Commission, which is FERC, also referred to as FERC, and then the PUCs regulate the utility side. For purposes of the discussion, the pipeline that I'm going to reference, the interstate pipeline, is going to be Southern Star. The reason I'll refer to Southern Star is because that is the interstate pipeline that KGS serves most of its customers from. And that is also, Southern Star is also the index that we referenced in KGS's tariff for purposes of penalty calculation. What happens when you transport, you have a marketer who will nominate your supply coming onto the interstate system. It will tell the pipeline how much it's bringing on and where it's going to drop the deliveries for you. At the point it reaches the demarcation or the city gate between the utility and the pipeline, it enters into the utility system and then it's transported along the utility system to the ultimate end use customer. Now, how did this construct come to be? Well, the evolution of transportation dates back 40 to 50 years, and I'm not going to rehash all that history, other than to say that originally the only entities who could participate in this type of transaction were pipelines, pipeline to pipeline or pipeline to utility, and those transactions had to be federally approved. During that time, pipeline entities like Southern Star, they were vertically integrated, meaning that they were responsible for buying, selling, and moving the gas along their systems. In the late 1980s to early 1990s, FERC issued a series of orders that ultimately led to the unbundling of those pipeline services, so that the only business that the utility or the pipelines were in at that point, or in today still, is the movement of the natural gas supplies along their systems. This construct allowed producers to sell their product to other entities than just the pipeline companies. Earlier, I mentioned that the federal government has also deregulated the price of natural gas. In essence, gas prices are market driven. So you may enter into a contract for a fixed price or an index price based on a published index, like Southern Star has a published index, but the price itself is not regulated. There are market conditions or market rules in place that help ensure that manipulation does not occur. And those are, if there are allegations of manipulation, then they will be investigated by the federal government. And some of those investigations are currently ongoing. But state PUCs like the KCC do not have any jurisdiction to address that market pricing. And I want to pause here. I understand the fact that what we regulate as the KCC when it comes to natural gas gets confusing, because we have a conservation division, right? We regulate the natural gas industry in Kansas. But that regulation has to do with casing type or cementing procedures or location and depths of wells, things that go to the extraction of the commodity itself. We do not regulate the price of natural gas. And although we set rates for our utilities like KGS, to the extent the natural gas supplies that they procure are prudent and are at market-based rates, then they're presumed reasonable. Now, Southern Star, like all pipelines, have provisions within their tariffs that govern the use of their system, how much it costs to move or store supplies along the system, or whether the movement of gas flows on an interruptible or a firm basis. Southern Star's tariff also allows for the imposition of penalties against users of the system for imbalances during critical periods. Oftentimes, those critical periods occur in the winter, and such conditions were certainly in place in February of last year. During February last year, Southern Star had in place what is referred to as an operational flow order. Ms. Daly mentioned this earlier with respect to KGS's system. They also have operational flow orders. Those require more stringent balancing conditions be applied in order to preserve system integrity. And because they are designed to incent behavior, if an entity uses more gas than they provide the system during those periods, then the pipeline has the right to penalize that entity and encourage good behavior. KGS contracts with Southern Star for space on the pipeline and for use of the storage facilities. And in many cases, it pays a reservation fee. And Mr. Nickel alluded to this in his opening. And those reservation fees are paid by the sales customers through the purchase gas adjustment or the cost of gas rider. It's basically the same thing, but it depends on which utility you're on as to whether or not it's a PGA or a COBR. KGS as a user of the system must balance its deliveries with the pipeline. It has to tell the pipeline how much supply it's going to be moving on the system where it wants the supply delivered. And again, these communications are important for the integrity of the pipeline. If pipelines did not require its customers to provide these nominations and have these communications with it, it could create issues along the pipeline segment such as pressure issues, where we could lose an entire segment of a system. And that would mean that the customers downstream wouldn't have any gas supply at all. So the communication is critically important. And similarly to how KGS has to tell the pipeline system, or how the pipeline in Southern Star in this example, how much gas and where it's going to bring the gas on and off the system. Marketing companies must do the same thing on behalf of the transportation customers. They too have to contract for transportation and storage along the pipeline system if they want it. They're not required to have storage along the system, and they're not required to have firm transportation service. They can do it on an interruptible basis. So that's something that people should be thinking about as they're entering into contracts with their marketing company. So again, what it means to transport is you enter into a private contract with the marketing company. That marketing company will nominate and balance for you. They'll bring your gas onto the pipeline system. They'll have it delivered into the city gate for you. And at that point, the title of that natural gas passes to the transportation customer, and KGS will move the gas to the customer's meter for consumption. So that's 101 transportation. I'm going to stop sharing my screen. Now, what happened during Winter Storm Uri? One thing I should have mentioned is that transportation, so marketing companies have multiple customers at a given point. They could have 50 customers at a given point on the system. So what they'll do is they'll pool those customers so they don't have to make a nomination for each individual customer. Rather, they'll make a nomination for a pool. And provided that the amount of gas used by that group of customers is close to the amount of gas delivered, there are no fees or penalties associated with those imbalances. This is true because it's understood it's nearly impossible to try to predict down to the MCF how much gas a particular customer might use. So in extreme weather conditions, make it difficult to determine how much a given customer is going to use on a given day or for a given period. Now, normally customer usages are projected based on historic usage and normalized weather conditions. Each customer uses its natural gas differently. Some use it for heat, some use it for the production of manufacturing of products. And the extreme weather impacts those usages and makes it difficult to determine how much supply will be needed. But KGS has tried to make it easier for marketers to estimate the quantity of gas for the transportation customers by having a required daily quantity amount that's calculated on behalf of each of those customers. So when a marketer is looking at how much gas do I need during this extreme weather condition period for my entire pool, I just need to add up all the RDQs for that group and make sure that I have that amount of gas to KGS to ensure that the pipeline or the utility has system integrity and has those supplies available to it. So the prolonged cold that blanketed the entire Midwest region that resulted in the lack of supply and the record high prices of natural gas led to the inability of many entities to procure sufficient supply. We know this happened. While some may have had natural gas supplies lined up at the beginning of the month, those supplies may have frozen off, creating a situation where the entity was out on the market trying to procure natural gas along with everybody else who had lost their first of the month supplies. Those replacements were likely priced at the daily published price for the respective pipeline on which the utility is or the customer is taking service. And despite the fact that supplies were scarce and prices were high, KGS did still have to provide service to its customers, and it had to have enough gas on the system to maintain system integrity. So what happened when the Transportation and Marketing Group failed to provide sufficient supplies to cover its load, it ended up in daily imbalances that occurred. And I have another graphic that I would like to share with you, if you'll bear with me for just a moment. All right, can you see the chart that I have here? It's called longs and shorts.
Terry, we can see it. Is there any way you might be able to enlarge it just a bit so that some of the numbers would be clearer?
Is that better?
That's much better. Thank you.
Okay. So I'll walk you through a little bit on this, on this, what this chart represents. If you are following across the top in the dark purple, let me go over here so I can use my mouse. This is gas day 11. So this is February 11th, running through gas day 19. So February 19th. So these are the days in question. I focused on these days because this is when the critical periods were in place, the OFOs and the POCs. And so that's when the penalties are being imposed for these days. The KGS system is comprised of two different systems. It's a K system and a T system. And for purposes of what we've done in this proceeding as part of the settlement agreement, we've just totaled everything for the entire system as a whole. And we've calculated what the longs and the shorts were for these given days. As you can see on gas day 11, as an example, there were 10,000 decatherm gas and short. So you'll see that it's short because it's got parentheticals around it. I've also color coded it for red to indicate that it's a short. And then if it's a long day, then it's in yellow. So for gas day 11, the transportation group as a whole was 10,000 decatherm short. On gas day 13, they were long by 7,000 decatherm. So you can follow that all the way across. Interesting, on gas day 17, there were 82,000 decatherm of supply short for the entire class of transportation customers. Now, so what this means is that even though KGS does not plan for the marketing companies and the transportation class as a whole, they still had to cover these supplies. And so it means that of the supplies that KGS provided, the transportation class actually consumed that gas. So we need to find a way to reimburse the sales class and keep the sales class whole for those supplies that were used by the transportation class. As we've talked about before, KGS's tariff allows it to impose penalties 2.5 to 10 times higher than the Southern Star published price during these periods. The blue row at the bottom is the Southern Star published rate for the respective days. And as you can see, gas day 11, we were seeing the published price was $9.62. That was a high price then. It wasn't a record price by any means, but it was certainly high. The $44.78 that occurred on Friday, I believe that was a record. I think the highest price prior to that occurred around the 2014 timeframe, and it was in the $30 range. Now, if you look at gas day 13 through 16, you see $300.29, or I'm sorry, $329.60. That's per unit of gas. So what we're doing is we have to take those amounts of Southern Star dollar amounts and apply it to certainly the shorts here to reimburse sales customers for what the transportation class used. And this was KGS's proposal when they came in on their waiver. They said, look, we don't want to charge the multipliers because, you know, 2.5 to 10 times $600 is certainly astronomical, as Ms. Daly indicated. The total penalties, if they were charged in accordance to the tariff, it would have been $888 million. Recognizing the financial disaster that would be, KGS said, okay, we just need to recover the stated price that was published for the given days. Staff has been on record as saying that, you know, we think it's commendable that KGS came in and asked for the waiver, but we thought that we could do better for the Kansas economy than simply applying that published Southern Star prices. We can all recognize that those prices are not normal, if you will. And so we didn't want to exacerbate the problem that was already in existence by placing additional costs on transportation customers. Now, I certainly understand that some have a view that the KGS penalties are they're penalties. Had the transportation customers and marketing companies as a whole shown up with the gas, we wouldn't be here talking about these penalties. However, that disregards the fact that supplies were scarce. Most entities were out there scrambling, trying to find supply. And as Mr. Grady has testified in previous dockets and is happy to discuss again today, staff is aware of entities who were unable to procure natural gas supply at any price. Such a position also ignores the fact that transportation customers are important to the economy. They employ thousands of customers or thousands of Kansas citizens. Although one comment I've repeatedly heard after Uri is transportation customers knowingly entered into these private contracts with the marketing companies. They've benefited from those arrangements for years. And now when a disaster hits, they want to be protected from the utility. We should just let them live with the consequences of their actions and let the penalties be applied. There are also sentiments that because the penalties are designed to incent behavior, if we don't charge something greater than the cost of gas, then we aren't providing the right market signals. We understand those sentiments, and in many ways, we agree with those sentiments, but we represent the public generally, and we take that mandate seriously. And because of that, we felt that under the extreme conditions that existed during Winter Storm Uri, that we should take an approach to mitigate the impact on all Kansas citizens. So we encourage KGS to take a closer look at the actual costs that were incurred during the event. What we did, well, we were not, and we have not tried to find the exact cost per molecule of gas that flowed during the event. And what we're trying to do is find a proxy for this Southern Star published rate, something that's maybe more equitable to everyone. As I indicated, the proxy needs to recover enough money from the transportation group to insulate sales customers from any costs that they should not have to bear. They need to be reimbursed for the costs or for the supplies that were consumed by the transportation class. The rate that we believe accomplishes this is the rate that is on the green line here. That is the settlement rate, settlement agreement rate. And as you can see, if you compare it to the Southern Star price, it's significantly less in most instances. The only outlier is gas day 18, but you can see that there's an incredible benefit being given to the transportation class by using this rate as opposed to the Southern Star. Now, while this is a wonderful deal for the transportation class and the individually balanced transportation customers, I, for one, don't believe that there's a participant in this docket who thinks that they're going to get a break like this in the event a future disaster occurs. Staff has made it very clear that the confluence of conditions that took place during Uri warranted this type of approach. We've been here, we've seen it now. We're not interested in reliving the scenario again. So it's our suggestion that people take a good hard look at the agreements they have in place and make sure that they're protected from such volatility on their contracts. With all that said, I'm gonna stop sharing my screen. We believe the agreement is in the public interest due to the confidentiality of some of the terms of that agreement. I'm not going to go into those. Instead, Mr. Grady is here and is happy to talk to you about those. But some of the key reasons why we believe the agreement is in the public interest is that it recovers sufficient costs from the transportation group as a whole to insulate sales customers. It provides finality to lengthy and costly litigation by having agreement among all the parties. It includes a parental guarantee to ensure recovery of costs from one of the marketers that was most heavily penalized and that has significant financial litigation looming on the horizon. This guarantee not only protects sales customers, but it also protects the transportation group. It allows KGS to move forward with securitization without the continued threat of further litigation because it represents a unanimous agreement with respect to the financial plan, as well as the waiver portion of this proceeding. While the agreement may not be perfect, it provides finality and assurances for cost recovery. And with that, commission staff recommends the commission approve the settlement as submitted. Thank you.
Thank you very much, Terry. This now concludes the opening statements. By my reckoning, we've been going here for a little over an hour and 15 minutes. And I think in the interest of giving our court reporter a break and giving all of us a bit of a break, at this time, we'll take a 5-minute recess. It is now 10:17. Let's plan on returning about 10:22. We are now off the record. All right, it is now, Robin, are you ready to go? Good, thank you. It is now 10:27 and we're back on the record. The next phase of this evidentiary hearing is the examination of witnesses. It's my understanding that in accordance with the agreements that were reached at the pre-hearing conference, we have two witnesses. Pardon me, the first of which is Janet Buchanan. Accordingly, I would turn to you, Ms. Daly, and ask if you would please call your witness.
Yes, thank you, Chair. Ms. Buchanan, are you on?
Yes.
Can you please state your name?
We need to swear in the witness.
Okay.
Yes, please.
Sorry.
Thank you, Ms. Daly. If you would, Robin, please. Robin, you're on mute.
I'm not used to being muted, sorry.
It's okay.
Ms. Buchanan, raise your right hand. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Thank you. Okay, Ms. Daly, please continue.
Thank you. Can you please state your name for the record?
Janet Buchanan, Buchanan.
And where are you employed, including your work address?
I'm employed by Kansas Gas Service at 7421 West 129th Street in Overland Park, Kansas, 66213.
And are you the same Janet Buchanan that filed testimony in support of the penalty waiver settlement on December 1st in this docket? December 1st, 2021 in this docket?
Yes.
And do you have any corrections or changes or additions to your testimony?
I have one correction on page 14, line 16. There's a dollar amount there, and it should be $52,446,581.
Thank you. And if I were to ask you the same questions contained in your testimony, would you provide the same answers?
Yes.
Well, at this time, I would like to move into the evidentiary record, the testimony of Janet Buchanan, and proffer this witness for cross-examination.
All right. I believe we have already admitted that, have we not? During the preliminary matters, Ms. Daly, am I correct?
Yes, you are. I wasn't sure in light of her change if we needed to do it again, but thank you.
Well, if under an abundance of caution, we will do that. Is there any objection to the admission of the testimony as revised, as amended? Hearing none, it is admitted. Thank you, Ms. Daly. Again, in accordance with the procedures that were accepted by the parties at the pre-hearing conference, the examination of this witness, the cross-examination of this witness, will be conducted by the commission, and then Ms. Daly will have the opportunity for redirect. That's the scope of the examination of Ms. Buchanan this morning. Accordingly, I will turn to my fellow commissioners and ask if they wish to examine Ms. Daly. I'll start first with Commissioner Duffy.
Thank you, Chair Keen. Good morning, Janet. How are you?
I'm well. How are you doing?
Doing good. If you would, please turn to page 20 of your testimony. On line 6, you discuss the rationale for applying penalties for unauthorized use during an OFO or POC, and these penalties are to deter conduct that places unnecessary burdens on the KGS system. Have you had an opportunity, as KGS had an opportunity, to use these penalties in Kansas previous to the event that occurred this last year?
No, it's my understanding that while we have issued a OFO, operational flow order, or period of curtailment in a couple of instances, it wasn't deemed that penalties were necessary in those instances. So this would be the first time.
Okay, and do you know how long these penalties have been in place?
From the research that I've done, they date back to 1997, 98 timeframe, when we had another even colder. It was a shorter weather event, but it was colder, and so it was part of some work that came out of that winter event.
So was that work in combination with the commission and the entities involved? To your knowledge, was it just KGS that participated in this, or did the other entities, gas entities, participate?
Yes, it was a proceeding before the commission where KGS proposed some tariff changes. There were, from my review of that proceeding, there were marketers involved in those discussions, and staff and CURB.
Okay, all right. But ultimately, the commission ruled and this became embedded into the tariff structure. Correct?
That's correct.
Okay.
Correct.
Have you ever had the opportunity to issue anything like a warning as it relates to an OFO or a POC?
Yes, I think that's happened fairly frequently, where the KGS will issue a critical notice or a weather advisory, giving marketers and individually balanced customers warning that we're seeing a weather event coming on that would cause strain on the system. And we've had a couple of those occur this winter. One for warmer than normal weather, where we were going to be having trouble if marketers and individually balanced customers didn't balance correctly. We'd have too much supply and not any place to put it. And we've had, again, some cold temperatures where we were concerned and wanted to make sure that marketers and individually balanced customers had adequate supplies. So we do give advance notice prior to issuing an OFO or period of curtailment.
Okay. And when did you start communicating with your customers, your transportation customers primarily, to advise them that this weather event was coming?
I'm going to look back at my testimony. I believe on page 5, we sent the critical notice out on February 4th.
So well in advance of the actual event itself.
That's correct.
And what was the response back that you heard from these marketers?
We didn't hear, to my knowledge, we didn't hear back from them, and there isn't an expectation that we would hear back from them on receipt of that notice. It was just us making sure that they were aware of what information we had about system constraints that might occur given the weather pattern we were seeing.
Okay. All right. Let me look right here real quick. I have a note and I'm not sure what my note meant. Okay. And in terms of the marketers who, it's my understanding that 93% failed to adequately provide, but there were a handful that did.
Right, and that 93% was on at least one time during that period of from the 11th to the, I believe our OFO went through the 23rd of February, that during that time, at least once they failed to provide sufficient gas to the system. There may have been other days where they provided more, but there were on whole 93% failed to do that on at least one day.
Okay, all right. Mr. Chairman, those are all the questions that I have right now. Thank you.
Thank you, Commissioner Duffy. Commissioner French.
Thank you. Morning, Ms. Buchanan.
Good morning.
Just a few questions. First, I want to start with just kind of clarifying the numbers of where we are with, given multiple settlements. And I guess, I think in the last proceeding, we talked about that there might be about $99 million of gas penalties that would be charged to the marketers. But then as I reviewed the materials here, we have a $26 million number for Symmetry. We've got 48.5 to other marketers, which would be about 75. But then I saw a number that was 65 as the total number, I think, in the settlement. I'm assuming maybe that had to do with the long gas. Anyway, if you could just clarify as a top dollar number, what KGS is attempting or expecting to recover from transporters or individually balanced customers as a result of this settlement, that would be helpful to me.
Okay. On exhibit JB-2, under the column negotiated gas cost penalty, at the bottom, you'll see the total that we will collect is $65,444,505. And
all right, that's helpful. And that is, so that was where I thought I was getting to. So that is the number after the consideration of the long gas. That's sort of the final number.
no, that's the total that we'll collect. Of that, $52,446,581 would be credited back to gas sales customers. And then the difference between those two, the 12.9 million would go back to marketers for the long gas.
That was the number I was trying to get to. All right. Thank you, Ms. Buchanan. That is helpful. Next thing I wanted to ask you about was, I'm trying to compare the two settlements that, and how this has evolved. And it seems to me the biggest material difference is that we are now going to blend in some of the daily callable gas in calculating the negotiated gas cost penalties. Would you agree that is kind of the biggest thing that is having the effect of reducing some of those penalties?
That's correct.
Okay. You heard, and I guess what's the dollar impact on that? Is it a reduction of about 25 million? What's the impact of that total?
It looks like it's about 34 million.
Okay, thank you. So pretty substantial. You heard Mr. Nickel in his opening statement make what to my ear sounded like a pretty reasonable point, which is an assertion that sales customers pay a premium to have access to that daily callable gas. I guess I'd like your perspective on whether you think that is a reasonable position. Obviously you're party to the settlement agreement, you support that. But do you think Mr. Nickel's characterization of that was fair?
Well, yes, gas sales customers do pay the demand charge that's associated with those gas daily callables, and they have been paying for those over time to have the assurance that that gas would be available to them. But I think given the global nature of resolving both this issue and the financial plan, the withdrawal of any opposition to the financial plan, that on whole, there is a great deal of benefit here for gas sales customers. And, without this settlement, there'd be no guarantee that the entity that owed the most would have paid anything. And so given that we now have a guarantee on that payment, I think gas sales customers will probably see greater benefit than they would have under the other agreement.
Thank you for that. I believe that's all the questions I have for you, Ms. Buchanan. Thank you.
Thank you.
Thank you, Commissioner French. Ms. Buchanan, good morning to you.
Good morning.
I have one question. I want to afford you all the latitude you think you need in answering it. It dovetails a bit right into the questions that were last asked of you by Commissioner French. So let me just ask this very general question to you. I want to try to kind of bring this whole matter. We're talking about millions of dollars here, and there's a whole lot of numbers that have been bandied about here during the course of the opening statements and through all of these proceedings. I want to kind of whittle this down to something in terms of what is this real impact to your average sales or transportation ratepayer. So my question is this to you, and I want to give you all the latitude that you think you need here in answering this. If we were to trace the scenario of events in this docket from where we started to where we end up with the settlement agreement, what, from your perspective, is the net financial or economic effect to the gas sales and gas transportation customers?
Okay. Well, I think given from where we started, the gas transportation customers, this agreement benefits, there's some benefit there for them in the reduction of the penalty to what the parties have agreed is a more appropriate measure given the extreme circumstances of this particular winter event. There's also a benefit to them for compensation for long gas that they provided among the transport customers that wouldn't otherwise be provided for under the tariff. And so there's some opportunity for transportation customers to recoup costs that they wouldn't otherwise be able to recoup. For gas sales customers, certainly they're seeing a little less benefit than what our initial proposal was, but given the concerns of all the parties and being able to come forward with a unanimous settlement agreement, again, as I indicated with Commissioner French, under any of the prior scenarios, there was no guarantee that the largest entity that owed a penalty, or the entity that owed the largest penalty, would have paid. And so we now have secured that agreement, and I think that provides the likelihood that gas sales customers are going to see a benefit is even greater now than it would have been under any other prior scenario.
I appreciate your answer. Thank you very much for your indulgence of the question. I have no further questions of Ms. Buchanan. Pardon me, I will turn back to Commissioner Duffy, please.
Thank you, Commissioner Keene, or Chair Keene. Running along that vein of thought there, Janet. So we had one outlier in terms of the original, the non-unanimous settlement agreement. And up until the nth hour, negotiations were going on. But, and everyone's alluded to, or you have and CURB has, that the potential that this outlier, this one entity, didn't pay. So what? All right. So then what would have happened? Run that scenario.
Well, if they didn't pay, of course, certainly KGS would have used all means necessary to attempt to collect from that entity. But the potential is that we would be tied up in litigation in both the penalty issue and the financial plan. And that would have delayed our ability to move forward with issuing securitized bonds to cover and the costs of the winter storm and extend the payment time period for gas sales customers to pay those gas costs over time. And any delay in that process would have, again, subjected them to additional carrying charges on the gas costs that are being delayed in recovery, and then also the potential for higher interest rates on the bonds if there's a lengthy delay. And so there were two areas there that were of concern. And if ultimately that marketer did not pay, then that would have been, let me get you the correct number from the prior agreement. That would have been 45 million less. So customers only would have recovered about, gas sales customers would have only recovered about $32 million under the prior agreement if we weren't able to secure the full payment from that one gas marketer. Whereas under this agreement, with that guarantee, gas sales customers will get the benefit of 52.4 million.
Okay, and what would have happened is this would have gone to the courts and there would have been litigation. Is that on the legal side? Is that what would have happened as well?
That's correct.
Okay. And this one outlier, this one entity is like the largest, right? Of the entities that have contracts with you, the marketers and they're the largest one.
That's correct.
So the most to lose or the most to gain.
Yes.
A reason to be greedy. Right.
Well, I mean, I wasn't privy to all of the discussions of the direct discussions in getting to this final agreement, and maybe staff can shed more light on that. But my understanding was that there was a discussion of that entity's ability to provide gas during that period of time, and some consideration given to what constraints they were facing and some financial implications for that entity. And so that was what was relayed to us as part of the rationale for moving in a different direction. But I believe Justin can probably provide more information around that.
And isn't it true that the settlement is with all the entities is because these entities, if they would have paid the tariffed penalty, would have their livelihood, their existence could be put into jeopardy as well?
Yeah, that's correct. If we had moved forward without asking for a waiver, if we'd moved forward with assessing penalties, those most certainly could have put companies out of business. And then if they pass those penalties on to the customers behind them, the end use transportation customers, then certainly those customers' livelihoods would have been at risk as well.
Okay. And it's my understanding is that there are in the agreement that there are payment dates when the payment needs to be made. And if not, then they're subject to perhaps the inability to work with KGS and be a customer of KGS any longer. Is that correct?
Yes, for all but one
All but one.
entities, the payment date is within 45 days of receipt of the invoice. And then if they don't pay, we reserve all our rights, and including the ability to ask or to restrict their ability to provide service on our system. And then for for symmetry, there is a payment plan over 4 years with dates set out for that. But the same constraint applies, that if they miss a payment, then there is a guarantee in place that would then automatically fulfill their obligation, whatever is left of it, their financial obligation, and then they're at risk of not being able to provide transportation service as a marketer on our system.
Okay. From your standpoint, the 45-day payment due date, do you believe that poses a real risk threat to any of those entities that owe you money at that time? Or do you believe they will all be able to make that payment date?
Of those that are involved in this proceeding,
Yes.
and those that are I think 4 out of the 5 largest, 4 of the 5 entities that owe the largest amounts are all involved in the proceeding. And to my knowledge, there's been no indication of an inability to meet that deadline.
Okay. All right. Thank you, Janet, for clarifying that. Thank you, Chair Keen.
All right, thank you. This concludes the cross-examination. I would turn to you, Ms. Daly, for redirect.
I have no redirect. Thank you, Chairman.
Very well. That concludes the testimony of this witness. Ms. Buchanan, thank you much for your appearance this morning. We're grateful for your being here. You may step down virtually. All right, very well. Again, in accordance with the procedures regarding witnesses that were agreed to at the pre-hearing conference, we have but one witness remaining, and that is Justin Grady of the KCC staff. I would turn to you, Ms. Pemberton, and ask that you please call your witness.
As staff calls Justin Grady.
Good morning.
Good morning, Mr. Grady. Could you raise your right hand, please? You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Please proceed, Ms. Pemberton.
Thank you. Mr. Grady, please state your full name for the record.
My name is Justin T. Grady.
By whom and in what capacity are you employed?
I am employed by the Kansas Corporation Commission as the Chief of Revenue Requirements, Cost of Service, and Finance.
What's your address at the KCC?
My business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66601.
Are you the same Justin Grady who caused to be filed in this docket on January 24th, 2022, a public and confidential version of testimony in support of the settlement agreement consisting of 34 pages, 1 attachment, 3 exhibits with subparts?
Yes.
Was this testimony created by you or at your direction?
Yeah, it was created by me.
And do you have any corrections to make to that testimony at this time?
Not that I'm aware of.
If I asked you those same questions today, would your answers be the same?
They would.
Okay, at this time, I would move the testimony attachments and exhibits of Mr. Grady be entered into the record.
Thank you. Are there any objections? Hearing none, they are so admitted.
All right, I tender the witness for commissioner questions.
Thank you very much, Ms. Pemberton. It is now time indeed for the cross-examination by the commissioners. At this time, I will turn to Commissioner French first and ask if he has any questions of the witness.
I've got a few. I'll be quick though, if Justin cooperates. Good morning, Mr. Grady.
Good morning.
First, I just want to be fair here. Staff is part of this agreement, and we've discussed that the most material change from this agreement and the prior agreement is the blending in of the gas daily callables. You heard my conversation with Ms. Buchanan, where I asked whether she thought CURB's characterization of that issue was fair, that sales customers paid a premium and perhaps they should be entitled to those gas daily callables. I think Ms. Buchanan's answer was it's a fair characterization, but all in all, the other terms of the settlement make it a reasonable compromise. I'd like to get your perspective, whether you have anything to add on that.
Yeah, so first of all, thanks for the opportunity to respond to that. I thought Ms. Buchanan did a great job. Actually, probably stole a lot of my thunder this morning, but my answer would be just a little more nuanced. I understand Mr. Nichols' position and I respect his views, but I do disagree with that characterization. There's a few things to remember. First of all, the non-unanimous settlement agreement also used the gas daily callable gas prices, right? It was a difference of weighting or priority, I guess you can think of. If you look at gas day 18, for instance, KGS didn't make any spot gas purchases that day, but the gas daily callable price is in this agreement for gas day 18. It's exclusively the gas daily price, and it was in the previous agreement. So it's the principal change in the methodology between the two agreements is a more equal weighted average blending of the gas daily gas costs and the spot gas cost. And so the principal methodology change is essentially a recognition or the assumption that KGS was using both of those sources of gas as its incremental supply options to shore up the deficiencies that existed and to provide additional system stability and support during the event. And why I think it's a nuanced disagreement, but it's important. It's an important distinction. Is I don't view gas daily callable gas as sort of an economic benefit that sales customers have been paying for, right? In other words, there are reservation fees associated with that gas, and those reservation fees in the agreement have basically been converted to a daily basis and are part of the gas cost. So it's not like, transportation customers got a pass for having to pay for those reservation fees first, but also, gas daily callable gas is, by its nature, it's a peaking type of a contract. It's a reliability product, right? It's a product that says, I'm going to pay you to ensure that that gas is available if I choose to call on it. And what I'm going to pay you is the gas daily index price, which ended up being, in this case, $330 or $650. I mean, it was still quite expensive price gas when KGS called on it. So it's holistically in a different universe than, say, first of the month callable gas, right? That is a true hedging nature, physical storage type of a product that says, if I choose to call on this gas, I'm only going to pay you $2.52 for that gas, right? So that, I think, is just a very critical distinction, and probably represents why I don't quite agree that sales customers have been paying for that gas as sort of an economic benefit. Now, it happened to be an economic benefit in this case for transportation customers and marketers, but that was mainly because there were other gas daily index prices that were blended in as opposed to just the Southern Star Index, right? What you find as you look at the gas purchases through all of these dockets is that it tends to be that spot priced gas, or when intraday priced gas, the gas that is purchased the closest increment to when it was burned during this event nearly always was priced at the Southern Star Index, right? And so in this case, KGS's reliability contracts, its gas daily callable contracts pulled from several other indexes, were priced at several other indexes. And that's ultimately what ended up making the difference. And it was mainly for gas day 17. If you look closely at the calculation methodology and you look at it, it really all comes down to gas day 17, right? The non-unanimous agreement that we had before the commission on gas day 17 is like 82,000 decatherms of gas that the transportation group was short. And that methodology said all 80,000, the first 80,000 decatherms of gas is going to be priced at spot price gases, or spot gas prices. And then the next 2,000 decatherms is treated as gas daily prices. And this agreement basically says, no, all 82,000 decatherms on gas day 17 should be blended across gas daily and spot price gas. And, it's just a recognition ultimately. I mean, there's a lot of ways you can look at this stuff, but it was a recognition that, the idea that transportation customers and marketers should have to pay for all 80,000 decatherms of spot price gas on gas day 17 might not have been the most equitable, cost allocated process and procedure. And there are certainly a lot of arguments why it wouldn't have been wrong. It just, ultimately, the more we thought about it, the more we dug into it, it became, look, if we're really trying to nail down the actual costs that sales customers were out on those days that need to be reimbursed by transportation customers, that's what resulted in the revised methodology. And that's what resulted in the revised settlement. But anyway, that was way longer of an answer than I expected to give you to that question. But I think that, encompasses the majority of my thoughts on the issue.
That is really good context. And it is a lot of extra information, but I appreciate it. I think that's the kind of information that we have to have, because it is central to the settlement and why the parties were willing to reopen negotiations. One more, I guess, quick line of questioning. I think it's paragraph 10 of the settlement. It talks about the fact that the parties did choose to reopen negotiations, and one of the considerations there, I mean, maybe I'm connecting some dots here. It seems pretty obvious to me, but it talks about a significant adverse financial impact to a party. I'm going to connect that dot to symmetry because it sounds like they were the one party outstanding. I noted in the settlement that Symmetry has agreed to get a guarantee from its parent company. It strikes me that seems to be a very important linchpin term, given the fact that there was some concern about their financial condition and ability to maybe pay penalties. Am I speaking out of turn? Is that a fair characterization? Was this an important term from staff's perspective to make this settlement happen?
Yeah, no, I mean, you're not speaking out of turn. That certainly was a very, very important provision. It's I know if there was a Symmetry witness on the stand, they would have a different view, and as negotiations go, they had their view and we had ours in terms of why $26 million is a reasonable number, or why we should have ever even entertained the idea of reopening negotiations. But for me, for us personally, it was a pretty cold calculated mathematical type of an approach, right? I mean, it just, Miss Buchanan referred to the number, and I'm not quibbling necessarily with it, but she mentioned, so under the previous settlement, right, if everybody but Symmetry had paid, then the number she had was $32 million is what sales customers would have recouped, right? But actually, I think Ms. Buchanan would agree with me that the number is actually $48 million, because the first payment that gets made doesn't account for that long gas, right? So under that previous agreement, if everyone but Symmetry had paid, then sales customers would have recouped $48,530,946. Okay. And what that means is none of the other transportation customers or marketers would have received anything for any of their long gas, right? And sales customers would have gotten $48 million, and then we would have began a process to further litigate and to try to get Symmetry to pay. And I mean, it would be pure speculation for me to try to nail down and attempt what the result of that would be, or how long that would take, or how much additional carrying charges would result from that, et cetera. But, the first step that was important, obviously, and key in getting this deal done was a revision of the mindset of what's the real pool of money here that sales customers need to be reimbursed for. And that was just that shifting in the weighting of the gas daily. And then once you get there, you look at the settlement agreement, and what we've basically gotten a guarantee of a recovery of is sales customers are guaranteed now, as long as nobody else defaults, and we don't have an indication that they will. Now, sales customers are guaranteed to get $52 million, right? And the sales, or the transportation customers and the marketers that were long, right, some of which are Kansas utilities. I mean, Sunflower Energy's in there, Evergy's in there. Now those people also are guaranteed to get their $12 million of long gas. And so, that corporate guarantee was important. And the certainty of receiving $26 million versus the uncertainty of potentially receiving $32 million or the higher numbers, that's where it came down to. And, we did some calculations, and I put it in my testimony regarding, what the known risks to higher carrying charges for sales customers could have been, right? 1 year delay in the financial plan proceeding, 1 year delay of issuing the securitized bonds would cost $6.3 million. And, anybody that has experience with how long it can take for a major contested case to make it through the appeals courts in this and many other states, a lot of times it's a lot longer than a year, right? So we were doing those kind of calculations and thinking about, and when I say that's the known risk, that's just the 2% carrying charges. The unknown risk that Ms. Buchanan referred to is very much real as well, right? We had 7% inflation last year in this country. And so the potential for interest rates to go higher, and what that ultimately means for sales customers, for the securitized bonds, those are the kind of sort of cold mathematical type calculations that we were doing on staff, and that led us ultimately to support this revised deal. So that's.
Well, I appreciate all that perspective as well. And yeah, if Symmetry had filed testimony in support of the settlement, I would have given them a chance to talk about the corporate guarantee from their perspective. But I think, you've provided a fair perspective of the value you assign to that. I mean, that helps. I guess the last line of questioning I'm going to go down here is more philosophical in nature. And, everybody's just going to have to forgive me for this, but you're the guy I want to talk to about it. And it's really about what we're setting up for the future by approving this settlement, if we were to do that. And I want to talk about the potential creation of moral hazard, both for marketers in the future and for KGS in the future. And I guess let's start first with the marketers. I understand this was a completely unprecedented situation, not something anybody expected to have to prepare for. Maybe it will never happen in the future. I'm not going to necessarily place my bets on that. But we've talked a lot about, or folks have mentioned, broadly the actions of the marketers during this event. And, I think there's some disagreement that there was any wrongdoing during the event. But I think one could argue that the actions of the marketers could be looked at more broadly, that perhaps they overextended themselves and their contractual obligations, so that when you had an extreme event like this, they weren't able to meet all of those obligations. I don't know, what their plans are for the future. Obviously, in this event, you're talking about a settlement that would sort of just make everybody whole. We have a backstop here. But let's suppose that this happens again, and marketers, individually balanced customers, find themselves back in this same situation. They've overextended themselves contractually again. I think Ms. Pemberton alluded to this in her opening statement, but what would staff's position be on the waiver of penalties if this were to happen later this winter or next winter, and you have sort of the same situation where folks aren't able to meet all their contractual obligations?
Yeah, so that's a great question. Moral hazard is, it's one of my biggest heartburns about actually both of the settlements that we filed, right? It is. There's no question about it. There's a reason Ms. Pemberton raised that in our opening statements. It's somewhat unavoidable in this case. If to the extent, if you're going to offer these marketers and transportation customers a break off of what they were sort of fearing would occur, which is those much higher penalties, then that's going to occur, right? And to a certain extent, people have been let off the hook. The reason we overcame that hurdle relatively early is just the fact that, what we had talked about was charging them close to or at the market price for the gas. It's the cheapest, even with the revision of the methodology, it's still $300 an MCF gas. So it was the idea that, if you're charging somebody 100 times what the gas price normally is, then hopefully that's enough of an inducement for proper behavior, I guess, in the future. And we're not letting people off the hook more than is necessary. It's just, there's so many other considerations, broader considerations, the economy as a whole, the fact that a lot of these marketing or these transportation customers already incurred, got gas bills of $70,000 to $100,000. And it's just, I don't know, it's not an easy question, but, I think the thing is, these things are so complicated and they're all different. And the 3 different gas utilities are different, and we need to make changes to all of their tariffs, and we need to sit down and have conversations with all of them. And it's going to take a while, right? Everybody knows that, but we are going to make changes. We are going to sit down collectively and talk about changes to this company's tariffs. We may be, ultimately there may be disagreement amongst the boxes on this screen as to what those changes are going to be. But, the hope is that going forward, we know maybe more precisely exactly how much gas people used on a daily basis, how much they put on the system. And then, God forbid something exactly like this happened again soon. I think I would advocate for let's even have a more prolonged, more detailed proceeding to try to figure out who were the bad actors, who were the entities that did absolutely everything they could to get every ounce of gas they could on the system, who were the entities that had true force majeures and their gas supply was just cut off and there wasn't anything they can do. I think maybe a more granular evaluation of behavior is maybe the way I would propose it for next time.
This proceeding hasn't been long enough for you, Mr. Gray?
Yeah, I know. But the thing is, when an event like this happens, you would not believe the number of conversations I have with 20-year-long professionals who go, I've never thought about that. I got to get back to you. So it's just, a lot of these tariff provisions haven't been utilized or reviewed in decades. And, a lot of times you feel proud about having 20 years of experience in a particular industry, but that's not a drop in the bucket of what it took to address, this is such a unique event. So anyway, I guess what I'm saying is if it happened again, it won't take as long next time because we've reviewed those tariffs that nobody looked at for 15 years. We know a little more now than we did then, but I don't know. Moral hazard's real, but just think about it at the FERC level too, right? I mean, Southern Star waived their penalties entirely. They didn't have a proceeding like this to say, no, let's figure out the actual gas costs and who owes what and who was. They just waived them. So, but when they do that, they have a clause that says, don't count on that next time. And I think unless you were just purely, risk averse or risk seeking, and you were just being imprudent in betting your company's future, then the next time there's an OFO and gas prices are really high, you have to assume that those penalties won't be waived every time. I personally am not aware of arbitrage or inappropriate behavior that occurred. I think what occurred was just simply a result of the fact that there were not enough molecules of natural gas flowing during those periods of time to serve everybody. I do. Sunflower is one of the marketers. Sunflower Energy Corp is one of the marketers that's listed there, and we just went through their general investigation, and this stuff is in our report in that other docket. But they could not buy gas at any price on gas day 17, and so they're facing a real world business choice, right? Do I continue running those units and sell that power at $10,000 a megawatt hour, or do I do a coordinated manual trip of every natural gas unit I own at precisely 9 a.m. on Wednesday, gas day 17, and they did the latter, right? So people responded the way that they were supposed to, I believe, during this event. And, and I think that goes a long way towards why Southern Star was offered was granted a waiver of their penalties, and why from pretty early on, our direction and view was, let's just figure out what the costs are. If we can, let's keep everybody whole and let's move on.
Thanks. As usual, a comprehensive answer. Well, my last question, I guess, is also philosophical, and it's pointed toward the future, and it's moral hazard from the perspective of the retail utility, KGS, because ultimately the customers are the backstop here. I mean, I think Kansas is in some ways more sophisticated than other states in that it's not just a direct pass through of market gas prices. I mean, we have required hedging programs that are approved. I don't know that every state does something quite as sophisticated as what we do. But other states have different schemes like performance-based gas purchasing mechanisms. And I guess where I'm going with this is, if this type of event were truly unprecedented and expected to happen once every 50, 75 years, I'm not sure that we would have so much angst, but I'm not confident in that. I don't think anybody is. I mean, we live in a time where clearly there are more extreme weather events happening every year. We're seeing different types of weather patterns that are subjecting these resources to strain. We also, just quite obviously are using natural gas for more things than we used to. I mean, there is a lot more competition for natural gas molecules, particularly by the electric generating sector. And so I think it's a very distinct possibility that we will have a scarcity event like this within the next 5 to 10 years. And from my perspective, it's unacceptable for once every 5 to 10 years to have an event where you have an extra $600 or $700 of cost placed on folks at one time. So what I'm getting to is, I know that we have hedging plans for our gas companies. I know that staff is recommending updating those plans, but should we also be looking at something where the customers are not just a backstop sitting there to pay whatever the end result is, that there maybe should be an alternative where the gas companies have some skin in the game in a performance scheme? And I say that both ways. If they do well, perhaps they get more of a return for those activities, but they also they're going to feel some of the pain if their strategies don't work out well. Maybe that doesn't work well in a scarcity event where nobody has any control, but I'd like your perspective on if there are any innovative mechanisms that you've heard of that you think we ought to be going down those pathways.
Well, that was a really good question. No, to be honest, I'm not.
It was a really long question.
It's a really good one too. But I'm not exceptionally familiar with other states' approaches, right? But I know that there are some states that say carve out, 5% of changes in fuel costs one way or the other, and try to ensure that the company has some skin in the game. And that's the sort of thing we could evaluate, if we needed to. I guess all I can offer right now, it's all pretty subjective, but it's all, very honest and heartfelt, is that, my view is that the people that make these decisions and that are thinking about these programs and hedging and revisions in contracting strategy going forward, and revisions in the type of financial instruments that are offered, it's truly been an all hands on deck, no stone unturned type of an approach. There's no exaggeration whatsoever in those words. I'm talking, to these people almost every week. I just had conversations, two 1 hour long conversations, one that was 2 hours long that my boss wishes would have only been 1 hour long, right? Just last week, about constantly thinking about, changes to the hedging approach, or changes to the contracting strategy. Should we instead have a portion of the supply that's just purely a fixed price supply arrangement going forward? Should there are different types of call options that can be used. But it's amazing though, because there's no easy answers, and the aid of hindsight is always 2020, and nobody ever wants to recognize when somebody has done a good job, but everybody loves to point out when you get it wrong, right? It's like, we could tell our utilities to fix the price of gas for next year at $5, and I'm sure they could do that, right? I mean, but if the market price ends up being $3, there will be a lot of upset people. And, we all have to go into a scenario like that saying, we're not trying to buy, we're not trying to get the cheapest price. We're just trying to have something that's predictable. And it's tough, it's a highly competitive marketplace, too, is what I would say. These gas utilities send their RFP to 25, 30, 35 different suppliers of natural gas, and they choose the cheapest option. I mean, it truly is just a market. We're all trying our best. I really believe they're trying their best. And, if they were disinterested or thought that, just the customers are going to pay it, I would see that, I would personally, I would observe that, because I'm involved in conversations with every one of the people that are actually making the decisions. And that's, one of the positives. I mean, there's a lot of negatives, but one of the positives of me personally being involved in every one of these dockets is I can observe, the personnel that are making these decisions, and I know they're all taking it extremely seriously, So I don't know if any of that helps, but it's just I don't actually think they need some skin in the game in order to get their attention and focus. But if anybody ever thought that was the case, then yeah, maybe we have to go down that road.
You actually perfectly set up my final question, which is a follow-up to that, which is, I mean, I know you enjoy this, Justin, but I also know how much time you've spent on this, and the staff resources we've spent on this over the last year, and the expertise that it takes to understand these hedging plans and the improvements that we're going to hopefully make to gas hedging plans for all of our utilities. And I do wonder, if we continue on this path where staff has to maintain the expertise to review, understand, and approve hedging plans on an annual basis. It's sort of a command and control style of regulation. To me, that seems very burdensome on the regulator. And would it be an additional benefit of moving toward a performance-based approach where perhaps the staff doesn't have to maintain that level of expertise to fully vet out and walk through the hedging plans, that instead we set up a system of regulation where it's about results. And is that perhaps a less burdensome form of regulation for an agency with limited resources?
Well, that's a good point. I guess the only thing that I would say is there's not a lot of command and control. It's more like we set high expectations, and if we have an indication that an issue is not as important as it should be, then we tell the utility, no, we want you to look more closely at this. And I've been very pleasantly surprised or pleased at the responsiveness that we've gotten from the utilities. I will say that, they all in a pretty short period of time came up with changes, real substantive changes to their gas purchase plans that were not cheap or free, but that would provide quite a bit of of price protection in the event that something like this were to happen again. But, with that being said, you make a good point. If I guess you could just rely on a system of incentives and or penalties to basically hope or assume that the utility is doing everything that it can in order to minimize costs. There are areas of, even within the purchase gas adjustment, right? There are areas where we do that, where we allow the utility to keep a portion of its capacity release sales or its as available gas sales. But one of the problems that we might face is that the amount of financial incentive that you'd have to give the company to just sort of look away and assume they're doing it right, might not be politically might not be politically salient or acceptable. It's just, I don't know. There's affordability needs to be considered as well. And, what we would be doing is shifting risk, right? You can't eliminate it, but we would be shifting it back to the utility. And there will be a cost associated with that too. There may be benefits associated with that, but there will be some cost associated with that potentially, especially the bigger the reward, the bigger the carrot or the bigger the stick. If we said something like, look, you can only pass through 75% of the changes in fuel costs, positive or negative, then there might be ramifications to that, right? That we'd have to consider obviously closely.
Well, I appreciate all those thoughts. Probably not necessarily the questions you thought you'd be answering today, but I had some deep thoughts.
Appreciate
all
it.
right. That's all I have, Chair Keen. Thank you.
All right, thank you as well. Commissioner Duffy.
Thank you, Mr. Chairman. Hi, Justin. How are you?
Good morning, Commissioner. I'm well, thank you.
Good. The phrase moral hazard, that if I can pick up on that theme, I think that it did concern me that CURB did not sign on to the agreement. And it was hearing from Mr. Nickel today explain why. I think he was spot on. But the moral hazard really, is it because a company was so much bigger than all the others that we could not let them fail? Just like the bank's too big to fail, we could not let them fail? Was it because we really feared that the litigation would go on for years and years, and as a result, ultimately it would backfire? We just did not believe the process would bear fruit at the end. So the fact that 93% of these companies failed in their endeavor, to me really does mean we need to have a look-see at this operation. And so I would like kind of your thoughts on that.
Okay, great. Thank you. So that, just, I guess the most recent point first, the 93% of companies failing. I mean, I'm sure it's accurately calculated, but I think it paints this situation into I wouldn't have used that statistic. I guess I'll just say that. I think I have a little bit of a different perspective than that. I mean, it's because for instance, I'm sure that doesn't account for, there would probably be a similar statistic that said on a daily basis, how many marketers or transportation customers delivered more gas to the system than they should have at least once, right? I mean, so that's a pretty unforgiving type of a calculation. And I get it. It's supported by the tariff and everything else, but this is such an extraordinary event. Everybody, I mean, nobody did everything perfectly, right? And it comes down to whether or not your gas supplies showed up in the fashion that you thought they would, and, you know, maybe how you manage some of those contracts. And so, you know, even some of the utilities that for 11 out of the 13 days, or the marketers, 11 out of the 13 days, they delivered more gas to the system than they used. But, you know, they're in that number, right? That 2 out of the 13 days they were short. It doesn't say how much they were short or anything else. So the other questions of, you know, is it because symmetry was too big to fail? No, it's not. You know, that never entered into I won't say that never entered into my mind, but I don't have any idea whether a $32 million invoice would have caused that company to declare bankruptcy or to not pay. You know, and it in part because it's contingent upon so many other things. I mean, they're a totally deregulated entity that we don't have access to their financial records or their books. I mean, there's contingent liabilities that are on their books that pertain to lawsuits that are still yet to come. So there's so many, that exercise involves way too much speculation, I think, to be a real consideration. The biggest consideration of ours was just, it's not like they were just threatening to litigate. They were litigating. They were the only party that was highly unsatisfied with the results of the non-unanimous settlement agreement. They hired experts. They had 10 attorneys. And so you know, we're looking at the real world situation of what if they appeal this? What if once they get an invoice, what if they take it to court and then they appeal? And all the while, the financial plan, we can't issue the bonds, the securitized bonds, because they're objecting. So that, you know, it really came down to nothing more than that from my perspective. You know, and then there's the bird in the hand versus 2 in the bush concept, and the certainty, and, you know, some of the raw math that we talked about before, that sales customers are guaranteed more out of this settlement than they might have gotten under the previous settlement. And so it's, yeah, you know, I thought Mr. Nickel did, you know, a good job of strenuously stating his points for why they didn't sign, but very importantly, they did not oppose, right? And it's sort of a weird middle ground in regulatory proceedings. You don't see it all that often, but if you know, if they would have felt strongly enough about the settlement that it was a bad deal for customers, or the staff was giving away the farm, they would have opposed the settlement in a heartbeat, right? That they're very competent, hardworking people as well. And so, last quick thing here. So the biggest disagreement that I have, and it's a respectful philosophical disagreement. The biggest disagreement I have is that the only moral hazard that I think is involved in this settlement, honestly, is the discount between the 32 million and the 26 million. I think that's the most questionable aspect of, if you want to call it that, of this settlement. But I became completely convinced in the reasonableness of the blending in of the gas daily costs with the spot price gas. I mean, there's several reasons for that, but I became completely convinced that that's the reasonable way to look at this. And that was a pretty big difference of opinion between ourselves and Curb. And, that may very well have been the straw that broke the camel's back, I guess. But I believe that that's the right way to look at this. And I think it's reasonable under the circumstances. So.
Okay. And I appreciate your comments and your further fleshing out. It's very helpful. So as we look at FERC, and they have abilities beyond us, so do you believe that they will respond and in a timely way as to changes that should be made at their level that would impact what we do here at the state level? Sometimes FERC just can be maddening in how they proceed and some of the things that come out, and other times I think they're spot on. But do you have faith in their ability to respond and respond quickly?
I don't know. Faith might be a little too strong of a word. I mean, I'm hopeful, but you do honestly get a whole range of opinions if you ask people one-on-one, sort of off the record. What do you think the likelihood is that FERC finds market manipulation and reprices those indexes? I have no idea. It's I mean, obviously those prices were unbelievably high. They were unbelievably high, but they were not unbelievably high only in Kansas, right? They were even higher in Oklahoma, and they were very, very high, record levels of high all across the central part of the United States and the southern part of the United States, right? And that, so, if you watch the testimony I gave before the legislative committees, I try to point that out. This was a issue that affected millions and millions and millions of natural gas users all across the central part of the United States. So, is that an indication that, well, maybe there wasn't market manipulation going on and it's truly just a once in a lifetime supply and demand issue? Well, I don't know. We don't have the tools or the ability to look into and truly figure that out. So whether or not they'll find market manipulation just specifically for the Southern Star Pipeline, I sort of hope that they do, right? Because that would be great. We have all the tools in place to be able to capture that money and funnel it back through where it goes, where it should go, rightfully go. The bigger, broader structural revisions that would need to occur in order to truly ensure something like this never happens again. I would say the things that can be done are being done or are being improved upon. Gas and electric coordination is a big one. As the FERC-NERC report highlighted that, it was either 23 or 28% of the natural gas production declines were related to the loss of electric power during this event. And so a lot of that coordination has been addressed and improved. It's going on in Kansas. I know it's going on in Oklahoma and Texas and other places. So, to a certain extent, this event was very much about the margins. Just a few things going better one way or the other would have made a big difference. This morning in SPP, we hit a peak that was within 1,000 megawatts or so of the peak demand during Uri. But the lights are on still, so this obviously the cold that we have right now isn't anything compared to Uri, but what you see is that the declines in natural gas production. When the molecules themselves are that far in decline, there's issues that are going to occur. So, that sort of thing, in my opinion, needs to be addressed by Congress. Needs to be a congressional, national level effort that says natural gas is just too important to our economy and to our society. And so we're going to have to mandate winter reliability rules for this. And of course, people are going to have to pay for that. And that's not going to be easy to get through Congress. So I certainly don't have much faith, I guess, that something like that would happen anytime soon. But around the edges, around the margins, there's a lot of improvement being made.
Okay, thank you. So also embodied in this agreement is that within 30 days, we're going to set up, open up another investigation into what, in terms of the tariffs, what perhaps we need to change, alter, mitigate, whatever. But when I asked Janet Buchanan about had these tariffs ever been used, she responded she was not aware that they had. Would you agree with that?
So, yeah, she would have a better, more intimate knowledge of that than I would. But I think the key is that the tariffs are used every day, right? In one form or fashion or another. They're applied and relied on. I think what she said is we haven't, made the decision to go ahead and seek to recover penalties. And so it will be such a all-encompassing and involved conversation when you get into what kind of changes to the transportation tariffs. Do we need to require electronic flow measurement for every transportation customer or every customer over a certain size? Do we, maybe there needs to be a rule that non-human needs customers, only non-human needs customers can be transportation customers, given the fact that they have a lower priority on the system. And they tend to hold less firm transportation and less storage rights. I mean, that's just two ideas out of hundreds, I'm sure. So, yeah, I agree with everything that Janet said about the tariffs, but it's going to be a big involved conversation about, a lot of these things. Their tariff today is the product of 40 or 50 years of refinement and tweaking, and so these things aren't going to change overnight. And all of our problems aren't going to be cured in one winter or two, but I don't know. We're all on the right path, towards the right path to make, I think, the changes that need to be made. But there's 30 or 40 boxes on this screen, whatever. There's probably going to be that many opinions or more about what needs to occur. So it's not going to be easy.
My hope is that we'll have a short list, because I can see where this discussion could go on forever, but that there perhaps it's bifurcated and there's a short list of something where perhaps most of everybody's nodding their head this way. And if it would be beneficial to get some changes made, we do that. I will say that I did appreciate Janet's comments that the next time this happens, and I do believe it's not if we have an event like this, it's when. That everybody understands now. We went through the rehearsal, the dry run, whatever, but everybody understands. And next time, there won't be such forgiveness. And I do think that is important to note, that everybody has been put on notice. And they're making changes however they see fit. I think that's important to note, and I hope we all get that, because while it's monetary damages that residential customers, and I primarily think of them, will be paying for a long time in every gas utility. And well, all the customers actually will be paying for a long time. Thankfully, we did not incur human loss like they did in Texas, where I call that a complete catastrophe of the highest proportion. Just very sad. And to have that weighing on that state, that doesn't go away. That's a stain they're going to carry for a long time. But companies, nonprofits, schools, people, they make choices. And hopefully now folks realize, to the extent that those choices will have consequences one way or another, and they're a little bit more educated about the choices they make. I do have to say this in conclusion, Mr. Chairman. This has just sucked the life out of our second floor staff and our attorneys, but primarily Justin, you, and the few hardy souls that have had to deal with this. And I do believe as commissioners, we need to be open to what can we do to ensure that there's going to be disasters, there's going to be catastrophes, but to the extent that we can ameliorate them, then I think that is our responsibility as well. But I do want to thank staff for their continued vigilance to get us to this point with every utility. And I just can't imagine how exhausting it has been, in addition to your regular everyday regulatory work. And with that, Mr. Chairman, I am done.
Thank you.
And thank you, Commissioner Duffy. It still is. Good morning, Justin.
Good morning.
We're still there. I just have a couple of questions for you. One a bit more specific than the other. And I'm going to leave the question pretty general because I don't want to inadvertently wander into information that's either confidential or highly confidential within the record. If we look at the one gas day that you consider to be most critical, that's gas day 17. And I think that was sort of critical mass for you. Is that a fair overgeneralization?
Nope. I'm sorry. Yes.
Oh, okay.
Yeah, that is fair. At first, for whatever reason, my brain, I think, heard, is that an unfair characterization? So no, yeah, you're right.
We have index pricing on that day that runs from $622 and change down to $129 and change, and even some below that. To what would you attribute this discrepancy or difference? How can that be? It was such a wide range on one day. To what would you attribute that?
Yeah, that's a very tough question. I think to do that question justice, we'd have to have 100 people here in a room, all of whom have had individual experiences with buying and selling gas on those particular pipelines during those days, to try to have an idea of how could that be. You know, obviously on gas day 17, there were very few trades that were made on the Southern Star pipeline, right? And that's obviously concerning and problematic. But and you know, Mr. Zakura and myself have had a lot of discussions about this. I mean, you know, if that was the highest price and it wasn't anywhere, and it was so much higher than any other pipeline in the area, then I'd maybe have, you know, more concerns that there's clearly, it's got to be market manipulation. It can't be just supply and demand. But what I look at is the fact that just south of there, just south of the Southern Star pipeline, on the One Oak Natural Gas Terminal trading hub in Tulsa, there were way more transactions that occurred that day and way higher volume. And the price was even higher than 677, right? It was 980 or 940. And then the next day, that One Oak Gas Terminal hub was $1,122 an MMBTU. So I have no idea how the price could have gotten so astronomical. But what we know is that there were severe imbalances in supply and demand for natural gas, right? We know that Southern Star, you talk to their operational people, their chief operating officer, they set new daily throughput records on that pipeline each day for 4 days in a row. You know, it's just the volume of gas. There was gas in the pipeline, but there was just so much demand for natural gas all across the central part of the United States during that time frame. And you know, the electricity price that gets the sort of the attention, the headline attention, is what the integrated marketplace electricity price peak was during that period of time, $4,200 a megawatt hour or whatever. But there were ancillary services type prices, depending on where you were within SPP. There were people literally being paid $25,000 a megawatt hour to produce electricity. Okay, so, I mean, you can pay more than $600 an MMBTU. You can pay more than $1,000 an MMBTU and still make money if you're selling your electricity production for $25,000 a megawatt hour. So the problem is there's just no, when you have scarcity situations like that, there's no cap, you know, there's no upper limit to what sets the price limit for what you're willing to pay. And maybe there should be, you know, but I don't know. Even that decision is not going to come easily because, and I don't know that this is perfectly right. I'm not saying I have all the answers, but if the gas price cap had been, say, $300 that day and that weekend, but gas is trading for more than $300 in Chicago or Houston, then what's to keep that gas here in Kansas flowing through the heaters and keeping Kansas customers warm and providing industrial processes? I don't know, but I mean, we know what price caps do. And sometimes they induce shortages. And so I don't know. It's a very difficult question to answer, but I guess it's only mildly comforting to me, but if comfort is the right word, it's that we weren't alone in this, and there were very, very high prices like this occurring all over the place. So it's as unfathomable as it is. So
well, it was a tough question. I appreciate your response very much. I think obviously what raises the red flag and the concern is not only the absolute amount, but the range. when the range is customarily, the absolute amount is usually much lower and the range is much tighter. Here we have an absolute amount that's much higher and the range is all over the place. So you've got a $500 differences within the range depending upon the pipeline. It's really troubling.
Mm-hmm.
Let me, I appreciate your response very much. Let me turn to my last question. Pardon me. It's a derivation of the question that I asked of Ms. Buchanan. I'm going to ask you to maybe put a little finer point on it, if you would, for us. Again, if we were to trace the scenario of events in this docket from where we started to where we ended up now with the settlement agreement, what from your perspective, and I'm trying to bring this down to something that isn't quite as esoteric as some of our discussion. I'm something that's maybe more in line with what customers would like to take away from what it is that we're doing here. My question is, what from your perspective are the most consequential net financial or economic effects to the average KGS, just the gas sales customers?
So we could calculate that, Chair. We could take that $52 million figure that will result from the commission's approval of this settlement agreement. We could take that $52 million and turn it into a per residential customer number. And that might get close to what just standard average residential customer would want to know, right? There's 660,000 or a little over 600,000 customers. So that's $86 roughly per residential customer, assuming all the sales customers are residential customers, and they're not. So that's rough, but out of the $500 or $600 worth of gas costs that these customers are going to be asked to pay off over 5 to 10 years, $75 or $80 of that is captured within this settlement agreement. And what it says is, sales customers, regular average residential customer, like my family. I mean, I'm on propane, but all my family, friends and family are KGS customers. And it says, you guys won't have to pay for the gas that the industrial customer down the road or the school down the road didn't deliver during those days, and they should have. That's what it would mean to the average residential customer, at least I think. But what I think was the most consequential shift or decision from where we started was a laudable position that, I think somebody said it in one of these hearings, no good deed goes unpunished. Well, KGS was under its right to send out $800 million worth of penalties. Now that wouldn't have worked. Obviously, there would have been litigation and lots of problems there. But it was certainly a reasonable position when they said, let's just waive the penalty. Let's just waive the multiplier, bill the Southern Star Index. There wasn't anything wrong with that. But, I probably deserve all of the criticism maybe for why we're here still, right? Because when I started really digging into those spreadsheets, I said, wait a second, if we just bill $117 million to all these people that were short, but there were these people that were long, like by $22 or $27 million, then sales customers are going to be benefiting on the back of this once in a lifetime, hopefully, event. And that's not right. Let's think about a netting process, and so we started down the path of, then we're talking about $99 million. And there's, that's a key provision, which is allowing the long gas marketers and transportation customers to be compensated for their gas, because there were a lot of people that were long every day or 95% of the days. And during that, that may have been because the tariff required them, or they already had their gas supplies lined up and they put the gas in the pipe, but they did what the governor and what the chair of the commission at the time and everybody else asked them to do, which was conserve. Shut your plant down, shut it down to, to plant protection levels. And so that too is an important part of this whole moral hazard discussion, right? We attempted to recognize good behavior and compensate for that good behavior, and that wasn't allowed for in the tariff, right? So that was a big change and a big shift away from the 117 million. And the rest of it was just a refinement, a refinement that either fortunately or unfortunately had millions of dollars of consequences. But because the dollars are so large and the per unit charge is so large, it's not hard to do that. But, then we're just refining and saying what was really the costs that the average residential or sales customer, should be protected from, should be compensated for. And that's where we got at the end, and there's a lot of different opinions about whether it's the perfect answer. I'll tell you it's not the perfect answer, but it's, I don't know. I feel like it's a good one.
Well, thank you. I appreciate the granularity of the answer. I certainly wouldn't even begin to claim that you were at fault for why it is that we end up here. So you're off that hook, I think. But I do appreciate the vast amount of work that you and your staff put in on the second floor. It has been substantial, and it continues to be. You continue to work through. We have a lot of other cases coming down the pike here. Also a great consequence to ratepayers in the state. And thank you for your effort, Justin. That concludes the commissioner questions. So I would turn this back to you, Ms. Pemberton. Any redirect?
I just have a couple of maybe clarifications that I'd like to get on the record. And Justin, I think this was in response to a question perhaps from Commissioner French. You had mentioned something about, Southern Star waived its penalties, right? And so the question becomes, why are we here talking about KGS's penalties, and would it be appropriate for KGS to waive penalties on their system? And so if you would just kind of discuss with us the differences between the obligations of Southern Star as a shipping pipeline versus the obligations that KGS has to serve customers. Can you enlighten us a little bit on that?
Sure. So, Southern Star obviously is an interstate gas pipeline. They don't take title to the gas unless they need it for operational purposes. KGS, on the other hand, does. They are taking gas off the interstate pipeline. They take title to it. They are responsible for lining up and procuring gas and purchasing that gas, delivering that gas. And so, I don't know, to a certain extent, the operational integrity requirements of the two are sort of similar. I think the main difference here is that, the sales customers, it was clear that the purchase gas adjustment clause, basically the mechanics of it, just the pure mechanics of it, are that if KGS didn't seek to collect at least the gas cost associated with that undelivered gas, then it was going to get collected by the sales customers, but for some sort of interruption of that tariff. And so, that the specifics in the Southern Star case, a lot of that information, we never got into it because they asked for a waiver. It was still a zero-sum game, right? If somebody took more gas off that system, then somebody else put more gas on the system. But it's more like utility to utility and big shipper to big shipper, as opposed to with KGS, it's sales customers for whom KGS has the responsibility to procure gas supply, and who didn't have, the sales customers don't have any ability to affect their fate. They're just relying on KGS to do the right thing and buy gas for them and to protect their financial interests. And so that would be one pretty major difference, I guess.
Okay, no, that hit what I wanted you to hit. That's really about the only question I had. The final one is just, is there anything that, in addition to what you've already discussed today, that you want to talk about that you haven't already had the opportunity to hit on?
No, not really. I mean, I appreciate the comments from the commissioners about, how much work it's been over the last year. It's true, but I would be, remiss if I didn't mention that, it's a group effort down here. There's a lot of hard work going on behind the scenes that, that the parties to this case don't see, or that the commissioners don't see. We tend to have one major policy witness on an issue like this, and I'm certainly heavily involved in these dockets, but I have a lot of support. And, this is an important docket. All the winter weather investigations are important. We're all Kansans and lived through what happened as well, and we're all paying for the cost of it. So I don't know, while it's hard work, it's important work. And I think that's what sustains everybody. That's what it's funny to me, because it's not really as exhausting as you would think, because it's so fulfilling and, provides a great sense of accomplishment. We think we're making good progress and making good policy to hopefully make this sort of thing less likely in the future. So.
Okay. Well, I don't have any other questions. So I'll conclude.
Thank you, Terry. Justin, I believe this concludes your testimony. Thank you for that testimony, and you may virtually step down.
Thank you.
I think we're nearing an end here. I think this concludes our hearing on the unanimous settlement agreement on a waiver of the penalties under the KGS tariff in docket number 21-KSGS-332-GIG. We remind the parties that we have a procedural schedule that certainly allows for post-hearing briefs. And as a reminder, commission order on this docket is due by March 7, 2022. If there are no further matters to come before this hearing, we will adjourn.
Mr. Chair, this is Dave Nickel. I just wanted a point of clarification. I believe in the pre-hearing conference that we had, the parties agreed to waive briefs. I just want to make that point of clarification. If I'm wrong on that, I'd ask for correction.
You're correct, David, and I don't know if there's a mistake in the script. It's on me. But at the pre-hearing conference, the next step is a commission order. So
very good. I stand corrected on the record. Nobody is going to be allowed whatsoever to file post-hearing briefs in this matter. Is that definitive enough? Okay. Very good. And there have to be sighs of relief. I'm sensing, but not exactly hearing around the table here. Very good. Anything further, Ms. Daly?
No, I was just agreeing with you. Yes.
I think there are no further matters, so we will adjourn. Thank you all very much. Take care.
Thank you.